Marbury versus Madison, 1803. Just the opinion summary and annotations. Annotation, primary holding. Congress does not have the power to pass laws that override the Constitution, such as by expanding the scope of the Supreme Court's original jurisdiction. Facts. Thomas Jefferson defeated John Adams in the presidential election of 1800, which was decided on February 17, 1801. Before Jefferson took office on March 4th, Adams' Congress passed the Judiciary Act of 1801, which created new district courts, expanded the number of circuit courts, added more judges to each circuit, gave the president more control over appointing federal judges, and reduced the number of Supreme Court justices from 6 to 5. This law essentially was an attempt by Adams, his political party, to frustrate the incoming opposition, which, since he used his new power to appoint 16 new circuit judges and 42 justices of the peace, a group known as the Midnight Judges. The incoming appointees were approved by the Adams Senate, but their appointments were not valid until each of their commissions were delivered by John Marshall in his capacity as acting Secretary of State. Justices of the peace were entitled to serve a term of 5 years. One of the new appointees was William Marbury, a long-standing supporter of Adams, who received the position of Justice of the Peace in the District of Columbia. There was a case with a handful of other appointees. Marshall failed to deliver Marbury's commission before Adams left office and was succeeded by Jefferson. With the change in administration, Marshall also left his position as Secretary of State, was succeeded by James Madison. Jefferson ordered acting Secretary of State Levi Lincoln to cease delivering the commissions, thus preventing the new appointees from taking the positions. He assumed that they could be considered void since they were not delivered on time. The machinations did not end there. Moreover, the Jefferson Congress proceeded to replace the Judiciary Act of 1801 with the new Judiciary Act of 1802 that essentially restores the initial Judiciary Act of 1789. It also sought to delay the Supreme Court in hearing the inevitable challenge to the constitutionality of Jefferson's maneuver by canceling his term in June 1802. Marbury then filed a writ for mandamus with the Supreme Court, asking it to order the executive branch to deliver its commission. Opinions majority: John Marshall, Arthur William Patterson, Samuel Chase, Bushrod Washington. This was a rare case. The right at the Supreme Court and the court for original jurisdiction, rather than as appeal from a lower court. Marshall and the other justices need to determine not only whether Marbury had the right to his commission, but also whether he had the remedy that could be enforced through the courts. Marshall found the remedy could be applied because no right could exist without remedy. Also, delivering the commission was a purely ministerial function of the executive branch. By ordering it to comply with the ministerial duties, the court would not violate the separation of powers by encroaching on another branch's discretion. Marshall also ruled that the writ for mandamus was the proper way to seek remedy, but grappled with the question of whether the Supreme Court could institute it. He identified a conflict between the Judicial Act of 1789 and the Constitution, each of which provided different parameters for the court's original jurisdiction. Marshall rejected Marbury's argument that the Constitution merely served as a foundation on which Congress could build with the later laws, finding that the Constitution trumpled any laws, and that Congress did not have the power to modify its Constitution through regular legislation. Explaining why the Constitution was supreme to all laws, it noted that the Supremacy Clause places the Constitution before the laws, and that judges must take an oath to uphold the Constitution. As a result, Marshall found that the section of the Judiciary Act of 1789 that they purported to give the Supreme Court original jurisdiction over these matters was invalid because it violated the Constitution. The Supreme Court considered for only 6 justices, and this time the Marshal's 4 justices opinion was unanimous because 2 of the justices recused themselves. Recused William Cushing, Alfred Moore. Case commentary. The Supreme Court uses its own understanding of the Constitution in reviewing the legitimacy of acts by other branches of government, even though this power is not apparent from the plain text of the document. This case establishes the legitimacy of a judicial review, as well as the supremacy of the Constitution over any other source of law. Many legal scholars for both Marshall period and the contemporary era found the opinion's logic strained, basing a sweeping conclusion on relatively little textual support. Still, the concept of judicial review has long been accepted without challenge. Unfortunately for Marbury, he never received his appointment as Justice of the Peace in the District of Columbia merely because the commission was not delivered before Adam left office. Syllabus. The clerks of the Department of State of the United States may be called upon to give evidence of transactions in the department which are not of a confidential character. The Secretary of State cannot be called upon as witness of state transactions of a confidential nature which may be occurred in his department, but he may be called upon to give testimony for circumstances which were not of that character. Clerks in the Department of State were directed to be sworn, subject to the objection to questions upon confidential matters. Some point in time must be taken when the powers of the executive or officer, not removable, and his will must cease. That point in time must be when the constitutional power of appointment has been exercised. And the power has been exercised when the last act required from the person possessing the power has been performed. This last act is a signature of the commission. If the act delivery be necessary to give validity to the commission of officer that has been delivered when executed and given to the Secretary of State for the purpose of being sealed, recorded, and transmitted to the party. In case of commissions to public officers, the law orders the Secretary of State to record them, when therefore the assigned and seal the order for their being recorded is given, and whether inserting to the books or not, they are recorded. When the heads departments of the government are the political or confidential officers executive merely to execute the will of the president, or rather and in cases in which the executive possesses a constitutional or legal discretion, nothing can be more perfectly clear than that their acts are only political examinable. But when a specific duty is assigned by law, individual rights depend upon the performance of that duty, it seems equally clear that the individual who considers himself injured has the right to resort to the laws of his country for the remedy. The President of the United States, by signing the commission, appointed Mr. Marbury as Justice of the Peace for the County of Washington in the District of Columbia, and the seal of the United States affixed thereto by the Secretary of State is conclusive testimony as the verity of the signature and as the completion of the appointment, and the appointment conferred on him a legal right to the office for the space of 5 years. Having this legal right to the office, he has a consequent right to the commission. a refusal to deliver which is a plain violation of that right for which the laws of the country afford him a remedy. To render a mandamus a proper remedy, the officer to whom it is directed must be one to whom, on legal principles, such a writ must be directed, and the person applying for it must be without any other specific remedy. When a commission to the public officer has been made out, signed, and sealed, and is withheld from the person entitled to it, act for detinue for the commission against the Secretary of State, who refused to deliver it, is not the proper remedy, and the judgment in diminu either for the saying itself or its value. The value of a public office, not to be sold, is incapable of being ascertained. It is a plain case for the ready-mills either to deliver the commission on a copy of it from the record. To enable the court to issue mandamus to compel the delivery of the commission of a public office by the Secretary of State, it must be shown that it is exercise of appellate jurisdiction, or that it be necessary to enable them to exercise appellate jurisdiction. It is an essential criterion of appellate jurisdiction that it revises and corrects the proceedings in the cause already instituted and does not create the cause. The authority given to the Supreme Court by the Act established judicial systems of the United States to issue rates of mandamus to public officers appear not to be warranted by the Constitution. It's emphatically the duty of the judicial department to see what the law is. Those who apply the rule to particular cases must, of necessity, expound and interpret the rule. If two laws conflict with each other, the court must decide on the operation of each. The courts are to regard the Constitution, and the Constitution is superior to any ordinary act of the legislature. The Constitution and not such ordinary act must govern the case to which they both apply. And the December term, 1801, William Marbury, that is Ramsey, Robert Townsend Hull, and William Harper by the council, severally moved the court for the rule to James Madison, Secretary of State of the United States, to show cause why a mandamus should not issue commanding him to cause to be delivered to them, respectively, their several commissions and justices of the peace in the District of Columbia. This motion was supported by affidavits of the following facts: that a notice of this motion had been given to Mr. Madison and Miss Adams, the late President of the United States, nominated the applicants to the Senate for the rights and consent to be appointed justices of the peace of the District of Columbia, that the Senate advised and consented to the appointments, and then commissions in due form were signed by the said President appointing them justices, etc., and that the seal of the United States were in due form affixed to the said commissions by the Secretary of State, that the applicants had requested Miss Madison to deliver them their said commissions, who has not complied with that request, and their said commissions are withheld from them, that the applicants have made application to Miss Madison as Secretary of State in the United States and his office for information whether the commissions were signed and sealed as aforesaid. That explicit and satisfactory information has not been given in answer to that inquiry, either by the Secretary of State or an officer in the Department of State. That application has been made to the Secretary of the Senate for the certificate of the nomination of the applicants and of the advice and consent of the Senate, who had declined giving such a certificate, whereupon a roll was made to show cause on the 4th day of the term, this roll having been duly served. Mr. Jacob Wagner and Mr. Daniel Brandt, who had been summoned to attend the court and were required to give evidence, object to be sworn, alleging that they were clerks in the Department of State, and are not bound to disclose any facts relating to the business or transactions of the office. The court orders the witnesses to be sworn, and the answer taken in writing, but informed them that when the questions were asked, they might state the objection to answering each particular question, if they had any. Mr. Lincoln, being the acting Secretary of State, when the circumstances stated in the affidavits occurred, were called upon to give a testimony, the object to answering the questions were put in writing. The court said there was nothing confidential required to be disclosed. If there had been, he was not obliged to answer it, and he thought anything was communicated to him confidentially. He was not bound to disclose, nor was he obliged to state anything which would incriminate himself. The question argued by the counsel for the relators were 1. Whether the Supreme Court can award the rate for mandamus in any case. 2. Whether it will lie to a Secretary of State in any case whatever. 3. Whether in the present case the court may award a mandamus to James Madison, Secretary of State.